Now, answering your questions about the law and legal issues. This is Legal Break with attorney Gary Bruce.
Hello there and welcome, Gary.
Thank you.
We've got we've got some great questions today. The first one is a Facebook question. Let's pull it up so we can read it. If a lawsuit is brought and an insurance company is not named in it, who pays if the case is lost?
Well, multifaceted question. I do injury cases, of course, but so mine usually involve insurance companies. But if it's not that, I mean, there may be a dispute over property. It may be a dispute over a number of things. You know, in a collection case, those don't involve insurance, so you wouldn't name an insurance. The interesting thing, though, and I've had jurors ask this question, why wasn't the insurance company named? Even if the insurance company is involved in a case involving a car wreck or injury, they're not going to be named. So you won't see them. So don't think, oh, well, they already got it done with the insurance company. Now they're just going after Jane Doe. That is not what's happening. The insurance company is still there. So don't be disturbed by that. You know, and we're going to talk in a minute about another thing that kind of dovetails into this, but you follow the rules that the judge gives, and it's not relevant really whether who pays. That's not an issue. The job of a jury is to determine what is a fair result. So anyway, let's get to the second question.
Yeah, let's do that. And I think it's a man on the street, so let's roll that.
Hi, Gary. What is the burden of proof, and who has to prove it in a lawsuit?
Yeah, I love this question, and we could spend days talking about it. I mean, because it's really difficult to conceptualize. So, you know, we deal with it all the time and think we understand it as lawyers. And then I went to a seminar this last fall, and I learned more about it than I ever thought. And it's like we throw jurors in a box to determine things based on who has the burden of proof, and I don't even understand it sometimes. But here's the deal. So we've all known this in criminal cases. It's beyond a reasonable doubt. That's a high standard, you know, that's beyond all reasonable doubt. But in civil cases, it's the preponderance of the evidence. So you hear that term, preponderance of the evidence. What's that mean? It means more likely than not. If you tip a scale, you just tip it. It's like a football field going over the 50-yard line. That wins in a civil case. That's the burden. We're not putting anybody in jail. We're determining something. It's not beyond a reasonable doubt. It's tipping the scale. It's getting over the 50-yard line. And the rules are hard to follow, but the judge will instruct on them, and a good lawyer will tell you about them in a case. But it is an interesting concept, and they differ depending on the type of case.
Oh, very, very good question. Thank you so much,
really
Gary.
is.
Yes,
Thank
and keep your questions coming, and we look forward to seeing you in the very next Legal Break.